What if I told you that the most powerful legal wins don't happen in courtrooms? They actually happen in mailrooms. In this video, I'm going to show you why the real power of law lies in paperwork, not the judge, and how most people lose because they never put their truth on paper. I've studied commercial law, contract enforcement, also the administrative process, and I'm here to show you how to win before you ever step in front of a judge. Now, before we dive into this, we're going to be breaking down the mental barriers and hoping to shift your mindset. As a matter of fact, it's not a hope. I am going to shift your mindset if you watch this all the way to the end. So make sure you are staying all the way to the end because we're going to be dropping some bangers and some heat that nobody talks about. Okay. Now, if this is your first time watching me, click the like button. Also press the subscribe button. Okay. And click the bell so that you get a notification every single time I post. Okay. Now let's dive straight into it. Everything that we talk about on this channel is to shift your mentality and help you understand the consumer law aspects and how to apply it. Because I can teach you the game, I can show you all the laws, I can make these laws make sense. But if you don't understand the importance of what I'm about to tell you today and the aspect of paperwork, then you will not win this debt discharge battle. Now, I talk to many people who claim I did this, claim I did that. And it's like, if you did everything that I talk about in my YouTube videos, there's no way that you would lose in court. Okay. There's no way that you would go to court with your evidence and they're going to deny you. Okay. Now, obviously, I talk about how, you going to court and be willing to go to court is the aspect that'll get you most of the remedies that you get, but the win happens before you go in front of a judge. You dig me? You have to win first before you go to a judge. If it's up in the air or whether or not you won or got your point across, then don't go to court. Don't try to sue a company by your emotions because you'll more than likely not get anywhere. Okay? So the power of law isn't in court. It's in paper. Okay, so let's dive straight into this. Okay, and before we dive into this, make sure you're staying all the way to the end. Okay, you stay all the way to the end, you're going to be able to gather up all this game. Make sure you're taking notes, have that notebook and notepad. Everything that I'll talk about, write it down and do your due diligence. Okay, this is not legal, this is not financial advice, so do your due diligence. You dig me? Now, here's the lie versus court and justice. We were taught that court is where justice happens, but the reality is that's not where it happens. Okay, you go to court to follow a process, to follow procedures. Okay, so by the time you are in court, you're often already on defense. The system favors contracts, not complaints, and contracts are enforced with paper. The courtroom is the last chapter and the contract is the story. So a lot of times when we look at court, we think that we're going to go in there saying, this is what happened to me and this, that, and the third. But they're not moving to make things right as it pertains to justice. They're seeing what the facts are. Okay, they're trying to see who is, who moved properly in regards to the contracts or in regards to the terms and conditions, in regards to the facts, not who feels like, oh, they was done unfairly. Okay, and obviously, if there is unfairness as it pertains to debt or as it pertains to credit, then absolutely. But you have to prove that it was unfair. You can't go in there and say, oh, it was unfair, and they're going to look at you and say, yeah, life is not fair. But you know what is fair? If you can prove to me where they went wrong in the contract, where they breached the contract. You dig me? Because otherwise, yeah, you're wasting valuable time. Okay? Because we could be taking other cases who can help us make even more money. Okay? Because a lot of people don't know that court is a bank. Okay? It's a financial transaction when you go to court. Okay, just know they make money when they take cases and when they close cases. All right. So don't go in there complaining with your emotions. Go in there and pull out, have your facts in order, have your evidence in order, and you're going to win. Now let's move on. Here's what paper can do that court can't. The proper paperwork creates, number one, a private record. All right. If you have that private record, that is going to put you in a position where you attended to this privately. All right. And it's record. Number 2, a timeline of evidence. You dig me? That is super important. Legal rebuttals without needing a lawyer. And leverage if it ever reaches court. Let's talk about that real quick. Number 1, if you have that private record, then that is on paper that you have challenged them privately and tried to do things behind closed doors. You tried to settle this matter, and if they didn't try to settle the matter privately and they decided to go public, okay, well, yes, we're going to bring all the private records to the service, to the surface of me actually going through this process with you. And you decided to do whatever it is that you did in the private because you thought, oh, I was going to get away with it. But I have record of everything. I have record of what I sent to you. I have record of the timeline, when I sent it to you, and I have record of everything that you sent back to me. This holds more power in court than you going in there screaming at the fences. Okay? And then the aspect of having those legal rebuttals without needing a lawyer. See, you want to have that communication. You want to be able to go through the rebuttal process before you get to court. So there is no new story to talk about. There is nothing that you wouldn't expect when you go to court. A lot of times we wait until court happens, and then we want to come up with our legal rebuttals. Then we want to go and challenge them, and then we want to, get prepared. But when you do the administrative process, this actually puts the banks in a position where the burden of proof is being shifted on them. Okay, so if the burden of proof is being shifted on them, now they have to come with those rebuttals. They have to come with those proofs before they pull up in court and just make up some mumbo jumbo or go based off of a piece of information and that you're not prepared for. If we talk about this privately, then no, there's no way that you guys can take advantage of my ignorance or me not knowing. Okay, and then we talk about the leverage if it ever reaches court. See, it's about the if it reaches court, because most times if you do this properly, they will settle, okay, before it goes to court, because the paperwork would do the talking, okay? You will send them a letter and you'll communicate your truths. You will communicate your conditional acceptance. You'll communicate your legal tender and how you are properly using it, and they're going to have to prove that you can't use it. And if they come up with some BS and say, and dishonor you or violate your rights during that process, all you have to do is show their violation. All you have to show is their dishonor. All you got to do is show how they breached the contract, because their argument is that you breached the contract. But if you can show proof that you didn't actually breach the contract, you just didn't pay in the way that they wanted to, you performed on a contract, and a contract only requires a performance. So if you perform properly, then they cannot get upset at you for performing properly, okay? And this is what you will showcase in courts. If you have your evidence, the timeline, you have that private record, you go through those rebuttals before you get to court. There's nothing that you need to say new. All you have to do is present the evidence, okay, on paper. This is when we talk about the administrative process versus litigation. Now, I did a video on this where I fully broke down the difference between administrative process versus litigation. If you want to be able to tap into that, the link will be right here, okay? Or down in the description. You can watch this after the video. All right. The administrative process, okay, versus litigation is better because number 1, it's private. Number 2, it's peaceful, and it's based on commerce and contract, not emotion or legal jargon. All right. So it doesn't always have to be you got to know all the legal jargon in order to get your point across. Okay. If you know the law, you don't have to have legal jargon. Just ask them for what it is that they need or what you need in order to prove their stance. If they cannot prove their stance, then they lose. No legal jargon needed. You dig me? So if your paperwork is solid, court becomes optional. All right. And not in the sense of, oh, I sent my paperwork, so I shouldn't have to go to court. If they keep violating your rights, then you make sure to take it to court of their violation. Not of you trying to get the court to discharge your debt and things of that nature. No, it's of their violation, okay? It's of their dishonoring. Do you guys gather that? Write that down, that you're taking them to court because of their dishonor and because of their violation of your rights. Not because you want the judge to discharge your debt for you. Okay, you bring it to court to bring the proof to the surface and the records and evidence to the surface publicly, so that now this puts them in a situation where it's damn, now they're putting out this information out in the public, and it makes me look bad. Or as a matter of fact, I could potentially be sued for my violations. That's when you take them to court. You don't take them to court after you fill in the paperwork and you want them to discharge your debt. No, that's not when you take them to court. You exercise that. You don't have to ask for permission for your debt to be discharged. You just have to notify them of it. And if they continue to collect on a discharged debt or a settled debt, that is double collection. If they attempt to do that, even though UCC 3-603 says that they forfeit their right when they refuse it, then that right there is a violation of contract law. All right. I hope you guys gathered that part. You know what I mean? So then we dive into how law is a language, okay? And paper is the voice. So here's some truths about the law, okay? Number one, affidavits unrebutted stand in truth, okay? They stand as truth, okay? If you send an affidavit and they do not respond to what you say point for point, then whatever they didn't respond to becomes true. Just like when they send you a letter and they say, oh, you owe 10 grand and you decide to ignore it. That is a unrebutted statement. So what stands true is that you actually do owe that 10 grand. Okay. This is why companies don't send me letters. Okay. They'll send you emails all day, especially when you come from a position of you will send them a letter back. Yeah, they're going to send you emails. They prefer to send you emails and get you to agree. But when they get to the point when they start sending you paperwork, it's literally because they know that you're not going to respond, or they hope you don't respond, because as soon as you don't respond to that paperwork, you've already effed yourself. Okay. Then we talk about notice, tenders, and conditional acceptance are enforceable offers. If someone says, hey, look, you owe me something, and then you give them an offer of a way to perform on whatever the contract is. If someone says, hey, we had a contract about something, you offer to perform in a specific way, then you can actually enforce that offer. That's what commercial and contract law says. Okay? You send a notice. Hey, I'm putting you on notice that this is my performance on this contract, this tender of payment. Here's the tender, coupon, okay? Promissory note. Unconditional promise to pay, unconditional offer of money. And if you decide not to accept this, I want you to provide, I will conditionally agree to your terms if you can prove X, Y, and Z. And these are things that you can enforce. This is not something that you're just going to be going and you're swinging for the fences, but you can enforce this. You can take this to court and say, hey, I did X, Y, and Z, and they decided not to give me X, Y, and Z. So wherever we're talking about right now doesn't really matter. Why didn't they provide me the information that I needed in order to prove X, Y, and Z? They're going to shift the burden of proof onto you too. But they don't really have much to shift onto you other than that you agreed to pay. But if that whole contract was bullshit from the start, fraud induced, things in that nature, and you are able to prove that or they wasn't able to prove that, this is where you can enforce. So then we dive into sending things certified, registered, because you want to have proof of communication. And you want to have good record keeping, okay? Then we dive into the UCC processes, understanding lawful and recognized commercial tools, okay? Under the UCC, it's not just like laws that people should follow. These are actual tools that you can use in the commercial process. This is why I talk about them. Because the tool of UCC 3-603 is that you want the refusal. They don't have to accept what you send them. But just know if they don't, then there's a discharge. That is a commercial tool for contracts. All right. So then we dive into you not screaming for your rights in court. You write them in peace. Don't go in court screaming what it is that you want done for you. You should have already did it for yourself already. And all you're doing is communicating that, hey, look, I already did the work. It's right here. I already exercised this stuff already. All right. So let's just talk about real examples of using paper power. Okay, let's first talk about debt collection. If you send a conditional acceptance, it shuts down any debt collection. Okay, because it now shifts the burden of proof onto them, essentially saying that if you agree, if you I will agree if you can prove X, Y, Z. If you can prove that there's a legal standing in law for this debt collection. Okay? When you have a court judgment, affidavits plus notices builds grounds to vacate. Okay? If you send affidavits and you send them notices, then essentially you can vacate a judgment with the proper evidence. Okay? Then we dive into a foreclosure. An administrative record proves dishonor and lack of standing. So when you start to challenge the company, especially through the administrative process, especially through the challenging whether they have maneuvered through with fraud, challenging whether the account was securitized, challenging or shifting the burden of proof onto them to prove that they have given the full disclosures, okay? And they decide to ignore, or they decide to dishonor you because they think that you're just a little fish. These are the things that you show in court, the administrative record of you challenging them on these things and you being ignored. Or better yet, them still participating adversely by selling your home without your permission. Okay? You will have the administrative record of you communicating with them. Okay? And then we talk about lawsuits. If somebody is attempting to sue you, especially as it pertains to a contract or a debt, you gotta have a private record that puts the burden on them before court is triggered. So if you already started that communication with them to dispute this very debt and they decide to still try to sue you, oh, my baby, I have a private record of me trying to communicate this with you, and you decided not to respond, or you decided to respond but still sue me because I didn't pay. But if I communicated with this through via privately and I was able to get my point across and you wasn't able to give me the proofs that I need, you wasn't able to or you refused my tender, right? And I communicated with this privately and you decided to take it public because of a ground that you don't stand on, then I'm going to show that private record. And now when you decide to sue me in court, now you have to prove your stance in front of the judge. Everything that I put in that private record, you have to prove right now in front of the judge. Before you get in front of the judge, what's going to happen is you're just going to go and show them the evidence before you walk up. Hey, this is what I have, this, and this. And I already communicated with you privately. So why are you acting like we didn't have this communication? Did you ignore me? Okay, there's a law called accord and satisfaction. You can't say you didn't get it because I sent it to this address, and this address. I even sent it to your law office because the judge don't like noise. They respect paperwork that's clean, lawful, and delivered early. Okay, if you go up there and you already, hey, this is my paperwork, boom, boom, boom. Oh, what do you have to? I have nothing to say. This is what I sent on this date and on this date and on this date. Go ahead and read it. And if they come in there and say, well, they already spoke to you. What are you coming to court for? It seems like they performed already. It seems like they tried to communicate and dispute this, and you decide to still sue them. What grounds do you have to sue them? If it clearly sees to me that they are performing on this contract. Okay. Then let's talk about how to start using law through paperwork. Okay. You want to make sure to send certified mail with every notice. Okay, if you're sending a legal tender or you're sending any type of lawful tender, then registered is probably the best case scenario because it's insured. You want to keep record of all your communications, not only from yourself, but anything that they send to you. Okay, you want to learn how to write affidavit of truths. You want to learn how to write notices of default and fault. You want to learn how to write conditional acceptances. Okay, you want to learn and reference applicable statutes and demand point for point responses. Okay, you want to always give an opportunity to cure. It proves good faith. Okay, don't beat the system with arguments. You beat it with documentation. So breaking this down straight off the bat, man, when you know the law, there's no way that you lose. I mean, obviously you'll lose if you don't know the law. And knowing the law is not just knowing some of the UCC things that I talk about. Knowing the law is knowing what the law is looking for. Okay. You want to demand point for point, meaning if they don't respond to a point, then they are dishonoring you. They are ignoring. It's a knowing and willful violation, where when you ask them a specific question and they are unable to respond to that specific question, then they are dishonoring. But then we dive into the aspect of, well, there's people who want to take them to court right away, this, that, and the third. But if you give a company an opportunity to cure, this actually looks good that you tried everything that you can. I gave you multiple chances to respond properly and you didn't. I moved in good faith and you're still trying to move in bad faith. You're trying to move in dishonor. When you move in good faith, your chances of winning skyrockets, because there's no way that a person can deny that, hey, this person gave you multiple chances and you still decide to play this game with them. Believe it or not, judges are more harder on corporations, okay? Especially a corporation that have no legal standing, that try to take advantage of someone. So it's not about them, justice, but those motherfuckers should know what y'all know what they're doing. Look, y'all get all the money in the world from everybody else, but this person actually did it right this time, and a judge will respect that. A judge will respect that you did it right. Okay. And I'm not going to say all judges. There are some corrupt judges out there. But when it comes to pro se, they have to give you the ability to be able to, they cannot have a legal bias just because you're pro se. If anything, they're supposed to give you more leniency because you're going and taking the actions on your own. And on top of that, you are more powerful than an attorney in the judge system. Attorney has to bow to a judge. You do not. Okay. Yes, you can hit the your honor, this, that, and the third. But even on the spiritual aspects, calling somebody your honor is almost you're putting yourself beneath them. And I'm not saying not to go in there, be respectful, this, that, and the third, but you got to think about it. The tyrant that is, having people bow their heads, the tyrant that has people, oh, don't look me in the eye, the tyrant that has you say or prove that you're beneath them, has their back to the wall, those are the people who are really scared. Those are the people who are really fearful of a person who will come in there and go against everything that they say. You get what I'm saying? You got to really think deeply and real spiritually about this, because it's beyond, debt discharge and the court system and procedures. But when you know certain things, you know the type of power that you do have. It's about having power. Okay? It's not about shouting your rights, because once you start to shout your rights, you start to challenge the corporation on X, Y, and Z, and you don't have no proof of no real challenge and no applicable law, no applicable statutes, no truth, just emotion. Yeah, then that's more of shit. If you gave me a better argument, you probably would have won. But I can't, okay? If you know all of this stuff, why don't you just try to communicate with them prior? So yes, paperwork is important. Don't limit yourself at how much paperwork you're going to send. Send as much as you can and actually finish it off. Don't just send a couple paperworks and there's no conclusion to your responses. You are not challenging what they send you. You're just sending letters and you're just disputing, even when it comes to credit, you're just sending the same letter. You're not really taking them through a process. You're not asking them for the information, and then when they don't give the information, you're not calling them out and saying how they're in violation and making them and giving them another opportunity to give you that information. If you reach out to them twice and they don't give you that information, yes, take that evidence and start the legal process, okay? But be confident in the process. If you're not confident in the process, keep sending them letters, keep communicating with them, keep shifting the burden of proof on them. And when they stop replying, when they stop responding, take them to court, okay? Because that's how you know you have the confidence, okay? It's about sending the right words on the right paper at the right time. And when you do that, you win in silence, not in struggle, okay? You don't have to sit there and struggle and communicate all these things. You should know exactly what you're going to court for. You should know exactly what you are challenging that company for, okay? Now, if you want to learn more, grab the complete that guide is down below, okay? It's only $47, but like I said, it's just like a stock. It'll push up to $97, okay? Maybe even $100 plus $200, whatever the case may be. It's not because it's about the money, but it's about the serious individuals who understand the energy that I'm bringing, not only on these YouTube videos, but they know and understand that, damn, he's kicking that game to me. And you know what I mean? Only a certain amount of people really need that energy that Nicholas is giving. It's an energy exchange, okay? And any type of investment that you put into me, I'm going to go ahead and put it right back in the YouTube videos. Y'all see the type of energy I'm giving for free, okay? But whatever the case may be, it doesn't matter if you grab it. It's still going to be there, and I'm going to still be dropping the game. So you can watch every single video. Make sure to like and subscribe to this video. All right? Next thing, if you want to work with me one-on-one, serious candidates only. I don't just work with anybody. So understand that my time is valuable and I know that your time is valuable. But if you do come on this call, it's about commitment. You have to be committed to the game. You got to be committed to investing in yourself, because I help people change their lives. I help people build generational wealth. It's beyond just debt discharge and understanding the consumer law strategies, because if you want to do that, you could just watch all of my YouTube videos from start to finish. But if you want more than that, you want to be able to become financially free, okay? You want to start building wealth, all right? You want to get access to capital. Tap in to the one-on-one mentorship, okay? It's an application process. So if you apply and I look at that application and I see that you're not a candidate based off of your responses or the questions that you decide to ask when you hit the application button, or when you get to the Calendly link and it says, oh, what questions do you have? And your questions are you asking me questions that I talk in my YouTube video, I'm not gonna give you a call, because it's a free one-on-one call, okay? Either between myself and my team, and we are people who value our time. And we want to speak to people who value their time as well, okay? Number 3, follow me on Instagram. If you want more strategic credit, motivation, wealth, understanding, consumer law, understanding, updates to my YouTube video, tap into biz.nick on Instagram, all right? And my last question is, have you ever had a situation where paperwork saved you? Share your story in the comment section. We would love to hear. Remember to like, subscribe, turn on the post notifications. And if you got all the way this far, go ahead and comment the word discharge, because we are breaking that mental slavery. We're going to change the mindsets of the people. And if you got all the way to the end, I know that you're a real one. I love you guys, and I'll see you next time.